Alrighty, looks like we are live. I'm George, one of the founders of SoloSuit. We also have here with us John Skiba, a friend from Arizona, does a great job representing consumers in debt lawsuits, helping them get things settled. We're gonna go ahead and talk about some tips on how to settle and negotiate with collectors. I'll just go ahead and make sure the audio is ready to go for John here. Let's see. Okay, it should be good. If there's any problem with the audio visual, just let us know in the chat. We'd also love to hear where you guys are from. So if you want to put your state into the chat, just let us know where you're from. That'd be great. We also reserve quite a bit of time for Q&A at the end, so you can put any questions you have into the chat as well. John, why don't you go ahead and introduce yourself, and we can get into some tips.
Yeah, George, no, I'd be glad to be here. Yeah, like you mentioned, I'm an attorney in Arizona. I deal primarily in consumer debt type issues, whether it's bankruptcy or I deal a lot with defending debt collection lawsuits, debt settlement, that kind of thing. And I run the Consumer Warrior YouTube channel where I put up a lot of videos, and I think that's probably how you and I actually got connected, is through our YouTube channels, where I put up a lot of videos. So that's me in a nutshell.
Okay, fantastic. And how about people are interested in here to find out, like how negotiation with collectors happens. If there's any tips for negotiating with collectors, what that negotiation might actually look like on a phone, email, letter. You mind giving us just a little bit of a rundown on how that looks oftentimes in your work?
Yeah, the couple main points that I tell people when negotiating with creditors. The first one is to really understand what type of creditor you're dealing with. And I really look at, I break it down into two categories. Is it the original creditor, the credit card company you took it out with? Is this American Express? Is it Citibank? Is it Capital One? Is that who you're actually speaking with? They charged it off and sold it to a debt buyer. Are you dealing with LVNB funding, Resurgent, Portfolio Recovery, some company like that? And that's important because it really influences the type of settlement you're going to get. If they've sold it to a debt buyer, the debt buyers pay pennies on the dollar for these things. They're not as invested, and they may be willing to take a lower settlement. Whereas the original creditor, they're in a much stronger position. They're the ones that lent the money. They're the ones that are taking the full loss. And not only that, if they decide to litigate it, they're going to have all the documents they need. So I always start with that, knowing kind of who I'm dealing with, to know how I should cater the response. As well as if you're dealing with an attorney for the debt collector, I think that's important to understand. I view my job as an attorney is to help whether it's the debt collector or the plaintiff's attorney, the creditor's attorney, to help them to explain why they should take the offer that I'm giving to their client or to the original creditor. Because if you're saying that you're going through some type of hardship, it's important that you're going to have to explain what that hardship is. Make it easy on them. If there's a medical issue, there's a family issue, you got to be careful of not providing too much financial information to them. But I think that you can't just say, hey, I'll give you 10 cents on the dollar without something to back it up as far as why they should do that. And so those are the types of things and factors that I look at when I'm starting to negotiate. And then the last one I would throw out there is their ability to collect. If it's something where someone is truly what we call judgment proof, where you're not in a position to actually, you don't own real estate, there's maybe you're unemployed, or maybe your income is Social Security, which is protected from garnishment. Those are the types of things that influence them and are kind of little signals to the creditor. Hey, this is going to be really tough to collect. Maybe we should just take what we can negotiate now and get a deal done. So those are the kind of the main things that I look at when I take on some type of settlement action.
Okay, great. What are some questions that consumers should ask themselves before making a proposal to repay the debt?
I would say, the thing you need to be realistic. You need to be painfully realistic, and particularly if you're offering some type of settlement proposal, as far as like whether it's lump sum or a payment plan, you don't want to overcommit. I see people do that a lot where they say, hey, I think I can pay $500 a month when there's no way. They're not going to be able to buy groceries if they're paying that extra 500 on top of it. And at the same point, you can't be too low in any type of proposal. If you owe $20,000 on a credit card, you can't come in and offer to pay them $800. They're not going to do it. They're not going to take a loss that big. So I really think you need to look at what's realistic for you, and then look at the factors that are influencing your inability to pay, or maybe what led up to the inability to pay. Often it's, maybe there's divorce, maybe there's medical issues, job loss, those types of things, and be prepared to present those things. Those are the types of things I think mentally that someone needs to go through if they're going to um, put forward a proposal. And I generally recommend go, unless they've already come to you with some type of proposal, you need to go to them with something uh, concrete. Don't just go and say, hey, I want to settle this. What will you take? They're gonna say, we'll take 100%. You need to go to them with a proposal, and then with information to be able to back it up why they should take that lower amount.
Okay, great. And kind of on that vein, I think a lot of people always wonder how do you negotiate with collectors to get the lowest settlement possible? And what does that really look
Yeah,
like? And is that even a thing? Or is that even the right mindset?
yeah, I can tell you often when things are particularly in the early stages. So the way the typical collection cycle goes is during the first 6 months, you're going to be dealing with the actual creditor itself in doing those negotiations, or sometimes they'll hire it out to a collection agency, which is different than like a debt buyer that actually purchases the debt. Collection agency, they're just a hired gun out there trying to get you to pay, do the phone calls all day long. When as far as and I bring that up just because initially there may not be a whole lot of wiggle room that some of these collectors have. If you call in, the person you're talking to is a customer service rep or just a collector, and they may have just a little window as far as what they can negotiate. They may not have a lot of authority. So I know it's uncomfortable. Sometimes I get much better deals when it actually proceeds to litigation, or when there's a law firm involved and there's someone who's maybe not as connected directly to the creditor, but they have a little more wiggle room to get the case settled, or they can even take it back to their client and say, hey, there's a lot of issues here. This person has a lien for child support. They got back taxes. Their income is Social Security. You better take what you can get and get out of this. So initially, and I should say this too, that when it's still with the original creditor, I don't think it's a bad idea to at least say, what programs do you have available? Sometimes I'm surprised at what some of the original creditors, what they will offer. I've seen significant reductions or like no interest payments for a certain period of time. You could ask for something like that if they have any programs available. But patience is the one thing I think people need to have in this process, which is tough because they're dinging your credit each month. But sometimes the older and this longer it plays out, the better deals you're going to get.
Interesting. And you're oftentimes negotiating directly with the lawyer, right? Instead of somebody on the floor of the phone call center.
Yeah, in my practice here in Arizona, it's rare where I'm just calling up, Capital One and trying to get something in place. Uh, I do find that to be difficult, just because, like I say, the people there, the customer service rep that you're dealing with the company, they often have very limited authority as far as what they can take. And that's why I'm saying sometimes the longer it draws out, the better, because maybe it's with a debt buyer at that point who's able to take much less because they haven't invested as much into it, or the attorneys have a lot of leeway in what they can negotiate. And also sometimes it's just nice because you're dealing with a person. Even with the collection firms, that can be hard, but sometimes with litigation, you're actually eventually you will get to an attorney or a paralegal or somebody you're dealing with, and just having to be one person to interact with rather than a different person every time you call in.
Right. And that seems like a helpful thing for getting the best deals.
Yeah.
For sure. Uh, okay. What about uh, tactics? Do you feel like there's any tactics like on the phone? Like if you say these words, then you'll get this settlement kind of thing. Like if you come in and you offer like 15%, and then you double it to 30%, and then you have it to then you only increase it by, instead of 15%, you increase it by 7% to like 37, then you increase it by 3% to 40. Do you think some things like that kind of works, like the Ackerman approach, or do you think just going for it and like making an offer where you just stick to the offer? Is that kind of a better tactic, or does it not really matter?
I do tell people, no matter what you offer, be prepared for a counter offer. So, I mean, I don't usually tell people to go in with their highest and best offer, because you call up a creditor and say, I'll pay you 95%, they'll come back at 98%, or something dumb like that. So, and then that's part of what I'm saying, that you need to do some work before approaching them about what's realistic as far as what you can do. If you're going to do a lump sum, and generally lump sums, you'll get a lower overall settlement than if you're wanting to extend it out. That's not true with some creditors. I've been surprised. I'm kind of seeing a shift in a lot of, particularly with creditor law firms and with some of the debt buyers, where they're wanting to take a higher amount over time rather than the lump sum, a lesser lump sum up front. So, there's some tactics that I hear people use a lot that I know don't work. A big one is, claiming bankruptcy, as far as saying, hey, if you don't take this, I'm going to file for bankruptcy. I say that's a little bit like the cry wolf thing. A lot of times the response is, okay, go do it. Particularly if you're dealing with a large creditor, they've already worked that into their system. They know a certain amount are actually going to file for bankruptcy. And the other thing is, almost everybody says it. So they know that not everybody's going to file for bankruptcy. And so I don't see that being a particularly strong tactic. I do think that knowing whether you can do a lump sum, how quickly you can do it, those things are important to know, and not coming in with your highest and best offer. If you know that the max you have is $3,000 to get this thing settled, don't come in at $3,000. That being said, I do think that having the ability to walk away and saying, I am going to we'll just keep dealing with this if they won't take it, you have to be willing to do that. Otherwise, when that's where you end up with bad settlements or bad overall deals where, they tend to fall apart in the future.
Nice. Okay. Great. Well, we're going to go ahead and get into the questions here in the chat. We've got lots of people on the show today watching live, so that's great. We're going to go ahead and answer your questions here that you're putting into the chat. This is as good a place as any for a little disclaimer, right? So Solo Suit is not a law firm. I'm not a lawyer. We don't represent you. John is a lawyer, however, he's not your lawyer. He's licensed in Arizona. And this isn't legal advice, right? We're just doing a webinar. So let's see the first questions. All right, so we got a question kind of from FR. I was sued by American Express, and then I used Solo Suit to answer. And then the court sent the case to mediation. Should I wait for mediation, or is it better if I make a settlement proposal before mediation?
Well, my approach to this, I always tell people, if you're going to request that the case go through private mediation, which most credit card agreements require or at least allow.
Well, most of the time they request arbitration, right? Mediation is going to be something different? I was thinking this might be like court-sponsored mediation.
Okay, you're right. I read that wrong. I'm sorry, but I heard you wrong. Okay, so if we're talking mediation, and so they're saying they filed the answer, and now the court's sending it to mediation. So court-imposed mediation, sometimes they're called settlement conferences. Those can be very helpful. For the reason of kind of what I mentioned before, that will be a time when you're going to be able to talk to the creditor and their attorney directly. This is where, and you have a third party there to help work it out. I don't think there's any harm in submitting a settlement offer before mediation. Usually, with the rules of evidence in most jurisdictions, it's Rule 408. States that settlement discussions are not admissible in court. So if you go to American Express, like this person is saying, and offer them something and they say, no, we're not going to do it, they can't turn around and say, hey, judge, you know what? They already offered us this money. Clearly, they owe the whole thing. They can't do that. Those aren't admissible. So there's no real harm in doing it. And it can kind of set the stage for mediation, because usually a mediator is going to ask, hey, have there been any back and forth between you two yet as far as settlement goes? I like mediation as far as a tool, particularly against original creditors and if they've been unreasonable in the past, because you're going to have an attorney there face to face or via Zoom or something like this to be able to try to get a better deal in place. And you're going to have this third party mediator that might twist their arm a bit saying, yeah, let's get a deal done.
Okay, nice. And just clarifying for folks, so you have mediation, it's a form of alternative dispute resolution. The other main form is arbitration. So if you just keep on going through your lawsuit, you're going to be going before a judge. Eventually, the judge will just decide. It's usually a winner-takes-all situation where the judge will make one person the winner of everything and the other person the loser of everything. And then with mediation, you'll go before a mediator. The mediator is going to try to get to an agreement between both parties and then have each party sign the agreement at the end of mediation. So it's not binding going in. Maybe at the end, both parties just dislike the mediator. You don't have to agree with anything. And then you can go on to court. And then with arbitration, it's kind of like a level in seriousness up from mediation. You'll have an arbiter. And you once you get into arbitration, you'll go in. The arbiter is going to make a decision, and that's it. You have to agree to the decision that the arbiter comes up with. So it's a little bit of a breakdown. Mediation's oftentimes a good option, especially if it's like in person with a human mediator. Some courts have been trying to do like an online mediation thing that I've heard bad things about for the most part. But an in-person mediator can be a good choice, and a lot of courts do that. It's oftentimes sponsored by the courts.
George, can I just put one point there?
Yeah.
So something I would recommend is I see this in Arizona a lot. I don't know if this happens in other jurisdictions, but usually with mediation, they want all of the parties there, and this is in court-sponsored mediation. They want all the parties, and I agree with you, in person is much better. But even if it's via Zoom, what I often will see here in Arizona is that they order the parties to be there, and the attorney will show up for the creditor, and then you show up, or you and your attorney show up. Before the mediation, I would make it clear that you expect a representative from the creditor to be there as well. The reason why is I kind of jokingly say, if we're going to do mediation, we all need to be equally inconvenienced. Just their attorney shouldn't be able just to show up and make these decisions. And often the attorney may not have all of the decision-making power that they need. So that's just kind of a pointer that I would tell people is before the mediation happens, make it clear, ask the court, ask the mediator that, hey, it's not just going to be a lawyer there, but I want a representative from American Express to be there as well, so that we can actually get a deal done.
Interesting. Okay, so you want the like a person for the plaintiff there, not just the person's lawyer.
Yeah.
Right. Nice. Okay. Rob, I have two judgments on credit. One has been vacated and another dismissed. Both creditors still enforcing and keep reporting monthly. They respond, debt validated. How can I stop it? Is there any specific FCRA claims I can file?
So we have two judgments. One's been vacated, the other dismissed. So this brings up a good point that there's a distinction between the litigation process and the actual claim, the underlying claim. So in this situation, we have one that's been dismissed, a judgment has been vacated. So that tells me there's no judgments in place, but it doesn't mean that the claim itself went away. They can still say that money is owed. They can still report it to your credit report saying that there's an outstanding balance, just like they could before they filed the lawsuit. And so, and that's why if you do get a lawsuit dismissed, you always want it dismissed with prejudice, meaning they can never bring it back. But I've even seen then where a lawsuit gets dismissed with prejudice, where the creditor will still call a consumer up saying, hey, do you want to voluntarily pay this? if you're negotiating within the litigation context, you want to get it dismissed, but you also want them to sign a settlement or a release saying that the debt's done away with. So I don't know if there's any the FCRA claims there. It would depend on if the debt's is it still within the time frame for them to report. It's roughly 7 years from the time it goes into a collection status on your credit report. So I think that's the main thing there is to understand. Just because a case has been dismissed or it's not in the court system doesn't mean that they can't still report if it's within the appropriate time period. I've even seen it, it's outside the statute of limitations. All that means is that they can't sue you. I've seen cases well outside the statute, and they're sending letters. They're still calling, saying, "Hey, do you want to voluntarily pay this?" So I think those are some considerations that might help you, know how to approach it.
Yeah, that's great. Yep. Yeah, so it's so for the listeners, right? It's important to recognize. Yeah, this guy Rob, he said he has 2 judgments, but basically, I wouldn't use the term judgment really. He has one case was vacated, and then another was dismissed. So most people would consider that to be a win. He kind of won both of those lawsuits, but it's important to recognize, right? So even if you have won the lawsuit, or even if the case was dismissed, they can still call you. Even if the statute of limitations has expired, they can still try to collect outside of court. That's an important thing. That's one of the reasons why a solo suit, we oftentimes think of settlement as the best outcome, because that's what's going to get like a full resolution on these things. What if somebody I don't think it happens very often, what if somebody took a case all the way to trial, like before a judge, and then the judge ruled that the person doesn't owe the debt? Can the collector still try to call them on the phone after that? After they did actually like fully win the lawsuit?
No, not if you win the lawsuit. And I've had that exact scenario happen with clients. I had one actually just a couple of years ago. We took a case to trial, we won it, and then 6 months later, they sent a collection letter to my client. I always joke you should be so lucky for that to happen, because that then often falls under the Fair Debt Collection Practices Act, where they're trying to collect on a debt that's not legally owed. If it's been adjudicated, if a judge has said you don't owe it, that the plaintiff didn't prove their case, that there was some defense you put up, whatever it is, then it's not legally owed. So that's a different situation. Or if you enter into a settlement agreement and they release it, so you negotiate a deal, it's in writing, you guys all sign off on it, and then they try to collect on it, that's an FDCPA violation. It could potentially be a Fair Credit Reporting Act violation as well, depending on how they're reporting it to the credit reporting agencies.
Great. All right. So this brings up an important distinction, that dismissal, even with prejudice, is not a win. It's not the same thing as winning the lawsuit fully. We oftentimes think about it as a win, but it's not the same thing as like going to trial before a judge and winning.
Yeah, you're not going to get garnished. I mean, that's the win, is you're not going to get garnished or your bank account's levied, but they still could try to collect on it through informal means.
Right. Okay. Well, we got about 5 minutes left, so let's see if we can't do a little bit more of a lightning round here. Maybe like 1 sentence responses. If we can try to respond to these guys in like 1 sentence. Got a lot of questions here. Let's see. So lightning round. How does someone claim themselves judgment proof?
I'm a lawyer. I don't know if I can do 1 sentence lightning round, but judgment proof. First of all, you've got to be really careful to make sure you are judgment proof. But if you don't have assets, if your income is exempt, like Social Security, often I have creditors, they'll ask for a copy of the award letter that you get, usually each January, something like that. They probably have information on whether you have real estate or not. You could provide information that your income is exempt, and that would be a way to do it.
Okay, great. And Hannah's answering a lot of your folks' questions here in the chat. Hannah's with SoloSuit, so look for a response from Hannah in the chat as well. Darren asked, how should I document a settlement negotiation?
It just needs to be in writing. I tell people, I don't care if it's an email, I don't care if they fax you something or if it's just a letter. Sometimes we get too caught up on it being a formal legalese thing. I mean, that's great if there's a formal settlement agreement, but if there's a letter that has the terms or an email that has the terms of what you're agreeing, you should feel comfortable in going forward.
Great. Okay. Terrence asked, does the plaintiff's attorney need to appear in court?
Yes, and if they don't, you should ask for the case to be dismissed. And hold the court's feet to the fire. I've had judges that say, let's just continue it. And I always say, hey, if I didn't show, I guarantee as a defendant the judgment would have been entered. Yes, they need to be there, and you can request dismissal in most jurisdictions if they don't.
Great. All right. Dave said that he is unemployed, being sued for $3,400. There's a trial date. Should I hire a civil lawyer?
Well, you're talking to a lawyer, so I'm biased. I mean, you're going to do. It's going to be do better. I mean, this is what we do all day long, and so a lot of it's procedure and things like that that can be difficult. The problem that you have is that my guess is even with a civil case, like there's a fair amount of work that needs to be done. You may pay a couple $1,000s for an attorney to avoid paying, $3,000. And so I would recommend, as part of the settlement approach, I often tell clients, go ahead and say, hey, it's going to cost me $1,500 to hire John. I'll pay that to you instead as a settlement just to be done with it. That may be the cheaper way to go overall. But if you don't have funds, it may be something where you're going to have to do a pro se or represent yourself.
Okay, great. Okay. Is D and S asked, do I state that I'm judgment proof as an affirmative defense?
No, that's not going to be affirmative defenses. I always say the easiest way to think of those, it's kind of like in a criminal law context, it's like what self-defense would be. Like, in a criminal defense, they may say, hey, you committed a murder, but you said, yeah, I did, but it was in self-defense, or something along those lines. In the civil world, affirmative defenses are, okay, maybe if everything that they're saying is true, but I still have this defense that the statute of limitations has expired, or that I actually made payment, or partial payment, things like that, that basically saying, even if everything that the creditor is saying is true, I still have these defenses. Statute of limitations probably being the easiest one to understand of those.
Okay. Miss Panda said, if I'm on Social Security, can they come after that income?
Social Security is exempt under federal law, and every state law that I know of protects that. Whether, as far as like a garnishment, the only thing I tell people to be careful of with Social Security is I would keep a separate bank account for the direct deposit of your Social Security from any other funds. In Arizona, if your Social Security income gets commingled with like income from another job or from another family member, it can lose its exempt status. Essentially, if they can't tell what's Social Security and what's not. So I always say have its own bank account to make sure that it's protected.
That's good. It's also important to note that just because they can't legally come after it doesn't mean that they won't try to, and it's up to you to stop them, right, as well.
That happens a lot.
Yep, they can certainly try. Right. Okay, we got a question from Gary. Does the creditor have access to my credit report?
Yes. I mean, they may not have access to everything, but yes, I mean, largely they do. And I always tell, the credit reporting agencies, TransUnion, Experian, Equifax, we often view them almost as these quasi-governmental agencies because they have such a big impact in our lives, but they're private companies and they sell the data to creditors. There's these things called trigger reports that they sell on the market to debt buyers and that, where they're monitoring your credit report for changes. And when there is, they'll notify the creditor. That's why I always say there's never a coincidence. People always tell me, oh, this lawsuit came at the worst imaginable time. It's because they probably saw a change in the credit report and that information was sold to the debt buyer or the collector.
Nice. Rick said that he said, hello, John, I'm a customer. Got John's kit. Made PRA disappear. There you go.
Awesome.
Nice. Good news from Rick. All right, maybe just a couple more questions here we have time for. Shilpa, what effect does settling have on one's credit?
Those are always hard to answer just because there's a lot of factors that go into it. Most settlement, it'll show that the account's been settled. It'll zero that out, but there may be a notation in there that'll say that it was settled for less than the amount owed. Uh, Depending on number of factors, it may increase your credit score significantly. It may really do nothing, depending on how old it was and really how much it was weighing on the score overall. So because it's hard to say exactly, I mean, it's better to have something resolved than unresolved. But as far as the actual number score is tough to say on an individual basis.
Already. Last question from Kevin. What's a typical percentage settlement with Barclays Bank?
Again, there are most all these are very fact based. Depending on your people's individual hardships. It's an original creditor lawsuit. If Barclays is the one reaching out to you, I tell people anything between 60 and 70% is a decent settlement. Some original creditors, they won't take less than 85. But I have seen original, like American Express, I have seen them stretch out settlements over years with no accruing interest. They want almost the whole balance, but they'll stretch that out over. I had one over 7 years, which was, I mean, it's a gigantic balance. But so I would say the original creditors, if 50%, I would take it. And it's probably going to settle somewhere between 60-70% of the total balance.
Great. All right, John, thanks so much for coming on the show. Everybody watching in, thanks for coming. Hopefully we got to your question either verbally or in the chat. Hannah's doing her best to keep up. And we do these things usually about weekly. So if we didn't get to your question this time, welcome to come on next week. And you can also email us at support@solosuit.com. If you have been sued for debt, just go over to solosuit.com. We also put a few links into the chat as well, which we encourage you to use. Those are links that will support John and his practice as well. So just go ahead and do that. And remember, we're always in your corner. We're here to help you out. Take care.